Thank you to the Institute very much for organizing this, and thank you all for coming out tonight. I'm very glad I was scheduled against the State of the Union as opposed to the college football game last night, which might have been a little bit more of a competition between us. I do welcome the opportunity to get to talk about my recent book, which is on judicial review in an objective legal system. Now, why should the average person care about judicial review? Well, first, let's remind ourselves. Judicial review, what's that again? That's basically the courts, the appellate courts, resolving disputes about what law means, what it permits on the part of government or private persons, and what it forbids. So, for example, questions like, does the Second Amendment mean I should or shouldn't need a license in order to own guns? That's a question of judicial review, right? Does the Fourth Amendment mean that the police need a warrant for that kind of search or that kind of stop? That's a question of judicial review. There are many, many questions about speech, about all sorts of things, right? But why should you, the average person, care? I don't mean to insult you by calling you the average person. You're the good guys. Well, for the simple reason that even the best made laws are useless if they're ill understood or misapplied. If freedom of speech, good law, good amendment, freedom of speech, right? But if freedom of speech is taken, understood as limited by another person's right not to be offended, then it doesn't protect what it should. If your right to make a living, again, part of good law, but if that is thought to encompass the right to be paid a minimum wage, then that doesn't protect what it should. Okay? So the way even well-made or well-designed laws are understood is crucial to whether or not they actually do us any good, whether they're protecting us in the way that they should be. Laws are, at least proper laws, are intended to protect us, to protect our rights. The basic idea is that if we have these rules, we will have a free society in which people can go about pursuing their happiness. Laws can't do that, however, if words are rubber. Whether the law's meaning is brazenly defied or inadvertently, in good faith, misunderstood. Either way, we suffer. Our freedom is constricted. So courts' interpretation of law in these cases is critical to our liberty, our having our freedom protected by the government. Now, most people who think and talk about judicial review, how courts should engage in this process of interpreting the law, most would agree that the role of courts in judicial review is to uphold the law. They disagree a lot on exactly how courts should do that, what steps should be taken in order to uphold the law, but at least broadly they'll agree, yes, the role of courts in review is to uphold the law. Do courts do that? Now, to this, many people would readily answer no. Without hesitation, they would say that's not what courts do. We commonly hear complaints like, oh, it's all just political. They do what they want to do. They just indulge their own ideological leanings, right? Or those two were appointed by Republicans. What do you expect? Or she's just a political token or something like that, right? Especially when the stakes are high and the public's differences are keen, for instance, over the Affordable Care Act, or over gun rights, or gay marriage, or Bush v. Gore back in the 2000 election. Particularly in cases like this, people often readily assumed that judges simply indulge their preferences, disguised under, the rigmarole of intricate reasoning, legalese in their opinions. This isn't just a popular perception, though. Increasingly, you find law professors and judges themselves voicing these kinds of views that courts are not objective or that they can't be objective. NYU professor Michael Seidman has written that we should relinquish the distinction between law and politics. It's a farce, he says. The Constitution is a symbol meant to invoke a mood or an emotion, but it offers no more strict guidance or discipline than that. Erwin Chemerinsky, anybody know who he is? He's a neighbor. He's right next door. He's the dean of UC Irvine's law school. He has written, and I quote, "There is no such thing as objective constitutional law, or objective law in any area," close quote. The prolific author and judge Richard Posner he's on the Seventh Circuit Court, he has been telling us for decades that we cannot separate law and politics. Objectivity is a pipe dream. Now, these realists exude the aura of sophistication, right? They're telling it like it is. They're educating us simpletons, who think that there might be objectivity to be had or that should be had. Even Samuel Alito on the Supreme Court, in a recent interview this summer, said, "Liberty means different things to different people." And he wasn't objecting to that. He wasn't distancing himself from that view. No, he went on to agree with it. Liberty, he said, is not something that is objectively ascertainable. Now think about that. If a critical concept at the core of what our Constitution is about itself simply means different things depending on who's talking, how are you, the ordinary citizen, supposed to know what liberty you're entitled to? And how does a given government official, be it a cop in the precinct or an official at the SEC or the Department of Justice or wherever it might be, how does that person know when he is trampling on a liberty that is supposed to be reserved to the people? It all depends on who you ask. According to Alito, right? It all depends on who you ask, not on what the law is. Again, that's deeply disturbing coming from a Supreme Court justice. Now, amidst such skepticism about objectivity in judicial review, along with some decisions that do occasionally deliberately, seemingly defy the law for ulterior ends, it's very easy to despair. Can courts get the law right? Can a judge be faithful to the law, whether or not he likes that particular law? Yes. The obstacle to objective judicial review is not that it is unattainable, nor that judges are a corrupt breed, partisans in robes. The deeper problem, in large part, I think the deeper problem is that we don't fully understand what objectivity is and what it demands in this realm. Consequently, even those in the debates over judicial review who wish to uphold objective law fail because they misunderstand it. They misunderstand what objective review is, what objectivity calls for here. So, I want to talk a little bit more about this tonight. It's hard to select, from a book that talks about an array of things all connected in trying to clarify the nature of objective judicial review. It's really hard to select what would be most interesting or useful perhaps in a brief talk to this kind of audience or that kind of audience. What I thought I'd do with us tonight is this. I'll say a little bit at first simply about the design of the book to give you an idea of what it addresses and why it addresses it, and I hope motivate you at least to know what's in there such that if you're interested in aspects you can look at the book itself. Then I thought I'd talk for a little while about objectivity in judicial review, saying something about what I think that demands. And then finally a few thoughts on who should be on the court. Just talk about that at a couple of different levels, the kinds of person that it might make most sense to have on a proper court. I've given you on the handout an outline of the talk, which also offers, let's see, I think I've got a list on there of some of my shorter writings. If you just wanted to dip into an article or two, I've got a list of those that are related to these issues on there. I also give you the contents of the book, which you can follow somewhat as I talk about the design. And there's one other list on there that I'll point to when we need it later on in the talk. Okay? So first, let me talk a little bit about the general design of the book. Broadly, it's in two parts, talking about objectivity in a legal system and then objectivity in judicial review. In debates about judicial review, it's relatively easy to say what we're against, what we oppose, where we find fault in what courts do or in various theories of what they should do. We're often, though, not sufficiently careful about what we are for and its justification and exactly what it demands of courts. And I came to think gradually as I began working in this area several years ago that you really can't understand proper review in isolation from thinking about a proper legal system more broadly. Because courts and judicial review are components of a larger system, and its purpose and framework establish the contours for proper review. I also found from studying different accounts of how review should be conducted, that views of courts' fidelity to law, which again a lot of people pay lip service to, courts should be faithful to the law, they'll say, right? But a lot of views of what that fidelity is, actually all of these views, inevitably must presuppose ideas of the identity of law, of what the law itself actually is that we're supposed to be faithful to. And that, in turn, inescapably depends on assumptions about the authority of law, of what renders some written rule a genuine, to-be-respected law. Thus, I don't think legal philosophy can avoid broader issues of political philosophy about the basic nature and purpose of government. So I also have in that first part of the book a few chapters on that, the authority of the legal system, the moral authority, and then what is the bedrock legal authority within a legal system. So again, the first part of the book lays the groundwork for an account of objective judicial review. In the first part, I've got chapters on the fundaments of objectivity itself, at least, for a layman, not for an epistemological specialist, but what are the basics of objectivity? Then what are the basics of an objective legal system? Then chapters on the core character of the rule of law and on the authority of law. Again, the moral authority and then the legal authority of law. My account of objectivity, just quick indication, portrays it as demanding but doable. I try to disentangle objectivity from some prevalent misconceptions of what it is, such ideas as that the objective is value neutral or seeing things from a bird's eye perspective, or it is simply given obvious to anybody who opens his eyes and is honest. I try to disentangle it from assorted misconceptions. I give what I think is a realistic account of objectivity, realistic to our limitations, to our fallibility, to the fact that it can't guarantee accurate answers, right conclusions, but also realistic to our capacities, explaining objectivity as a discipline of thinking that we can and should adhere to in order to get things right, to understand whatever the phenomenon in question is that we're trying to understand. It's a matter of using our minds by the guardrails of logic to understand the object in question. Now again, I'm just giving you, that's what I elaborate on in much more care, with much more care in the discussion of objectivity itself. The objectivity of a legal system, I argue, basically turns on three components: what the legal system does, the content of its rules, the substance of its laws, how it does it, how the law is administered, how it's executed, how laws are adopted, how they are enforced, punishment, how rule makers are elected, all of the administration of law, the how of a legal system, and the why of a legal system, meaning the authority. Why does it do what it does? Does it engage in the laws, the lawmaking? Does it make the laws and enforce the laws that it does in accordance with what gives it authority in the first place? So the what, how, and why in that sense of authority, those are the three pivots for an objective legal system, which again I elaborate at length, and I've given some other lectures that talk about that in much more detail. But important here is the fact that the function of a legal system really drives our understanding of all the rest. We have laws in order to do a job. There's a practical mission for a legal system to accomplish. And reference to that is incredibly helpful, I learned, whenever you're trying to figure out how should a legal system be structured, what should the content of its laws be, etc. All the different questions that it's natural to have about a legal system, the answers are going to come from, well, why do we have that thing in the first place anyway? What is it that gives them the authority to force us to obey these laws? So function is incredibly helpful, and I try to emphasize that in the discussion there. Part 2 of the book zooms in on judicial review. I've got a lengthy critical survey of the 5 dominant schools of thought, which I list on the handout where I talk, in chapter 6, I guess it is. I go through a lot of the most popular scholars, popular with scholars as well, theories of how courts should engage in judicial review. All of these, I argue, suffer from fatal confusions concerning the authority of law or the objectivity of law, or both. Then got a chapter charting my own view, and then a chapter which addresses something like the question, but how do you get there from here? If you don't live in an objective legal system overall, you live in the very imperfect legal system that we're now in, what would I prescribe in terms of moving us in the direction of proper judicial review? So that's a quick overview, quick picture of what the book is all about. Let me now turn to the question, so what would proper judicial review look like, at least in outline, right? Just to give us a sketch, some idea for tonight. And here again, to answer the question, our compass must be function. Here, what's the function of judicial review? Well, basically, to ensure that the law is what governs. To understand correctly what the law requires or forbids, and how that applies in the disputed case that's coming to the court for review. Okay? Essentially, I argue, objectivity in judicial review demands 2 things. Unswerving focus on the law, and appreciation of the contextual character of law's meaning. Objective judicial review demands sole focus on the law, understood in logical light of the relevant context, both local and large, meaning the facts of the immediate case, that's part of the context, right? The facts of the immediate dispute, as well as the wider principles governing the entire legal system. So let me elaborate a little bit on both of these things, starting with the second, the contextual character of meaning. A person must understand the mission and authority of a legal system to properly construe any of its discrete elements. In a proper legal system, all of its parts, all of the law's powers, all specific rules and policies are reflections of a central animating purpose. Their legitimacy depends on that. Correspondingly, and this is important, their legitimate meaning depends on that. A legal system's authority determines what its particular provisions could possibly mean in order to be consistent with that authority, and what they could not mean, since certain interpretations of law would exceed the government's authority, would allow it a power that it doesn't rightfully possess. Thus, contextual interpretation must respect the bounds of government power. We must understand the overarching function of law and the authority of law in order to derivatively understand the proper meaning of any single component. For example, the right to free speech couldn't protect speech that violates others' rights, such as fraudulent misrepresentation, right? I mean, I could speak in a way that fraudulently misrepresents the product that I'm trying to get you to buy from me, right? Well, free speech couldn't protect that because that would involve a violation of others' rights. And the whole purpose of the law is to protect everyone's rights, okay? So that's just a quick example of how you can't interpret, if you understand the abiding principles that govern the whole system, that's going to help you figure out what a particular law means and couldn't possibly mean, okay? Because that would be beyond the authority of the government. So you've got to get the whole picture straight, in a certain sense, in order to get particular disputes about rights or laws straight. And notice, just as an aside, but when thinking about the contextual character of law, in many, many arenas in life, people readily distinguish between what they call the letter of the law and the spirit of the law, right? Not even when they're talking about laws, they just might be talking about rules in a lot of different contexts, right? But notice what they're doing there when they make that distinction, and it's often a valid distinction between the letter and the spirit of the law. They're recognizing that context counts, right? That the background and the whole reason for having certain rules informs an intelligent understanding of what a particular rule would and wouldn't require in particular circumstances. Same basic idea, okay? My contention in regard to the law is that the letter of the law can't be understood without understanding its spirit, meaning its purpose, the purpose, the principles of the larger legal system as a whole. Just to come at this from a slightly different angle, the law is philosophical. Our Constitution reflects a definite theory of government. In creating the powers that it does, and in those that it does not create, in the powers that it does not give the government, and in its structuring of powers, in the safeguards it builds in, it is taking a stand on the proper relationship between government and governed. Correspondingly, courts must make use of that philosophy when they're considering the proper meaning of its disputed laws, of any of its disputed laws. And notice, for courts or judges to make use of that philosophy is different from their imposing their own philosophies onto the law, okay? Not endorsing that, but to say that they shouldn't be imposing their personal philosophical beliefs or preferences is not to say that they should have nothing to do with philosophy. They've got to discern the philosophy that's animating all of the particular laws that have been enacted. And this entails that being objective on their parts requires judgment, which a lot of people resist. That's when it gets scary for a lot of people, and understandably so for some, in some situations. But critics of activist courts often imply that judicial review should be a no-brainer, with the answers self-evident. Problem is, it can't be. To understand the correct applications of abstract concepts to particular circumstances is an intellectual process, often a difficult one. I mean, especially the kinds of cases that get to the appellate courts, they're often difficult. Did the police have probable cause for that stop? Is it freedom of the press to withhold information from a government investigation, because you don't want to divulge your sources? Is that refusal to do business, to cater those two women's marriage, right, their wedding? Is that refusal to do business the free exercise of religion, or a violation of their rights under equal protection law? Now, my point here isn't to try to answer any of these questions, but it's simply to say, to answer them, you gotta think. You gotta judge. This isn't just, oh, look and open your eyes and see. No, these are hard questions. And they take thought, they take reflection, they take judgment, okay? Judicial review is not a no-brainer. And we can't convert this fallible process into a foolproof method that can guarantee us all the right answers. So our expectations of objective review have to be calibrated accordingly. Our expectations themselves have to be objective. So while it's right to insist that courts honor the law, what was written and enacted, it's important to understand what can't be written. Meaning. Now, this is a subtle point, but it's really important. Meaning can be indicated by words but not contained in words. It's not reducible to words. Rules can be written. The understanding of those rules can't be. And that's why we need judges, human beings, to weigh logically, to exercise objective judgment. Meaning can't be outsourced to physical symbols, as some of the textualists, for instance, suppose. Meaning is an intellectual phenomenon. So it's a mistake to condemn judges for using judgment to discern meaning, as critics often do. No, their objectivity depends on how they use judgment, but not the sheer fact that they use judgment. They have to. Now, I say much more in relevant chapters to distinguish an objective approach from what dominates today. I argue that the shift from the presumption of individual liberty to the presumption of constitutionality, which has gone on for almost 100 years now in this country, has warped judicial review in very destructive ways, and that the courts need to jettison so-called three-tiered scrutiny and adopt a single standard across the board. We can talk more about that if you want in the question period. I won't get into it unless you want to. We can talk a little bit more about that. Yeah, I'll skip a little of this. Here, I think I should move on to the first guidepost. I had said there are two essentials to objective judicial review. And the first one is the one that probably sounds really obvious, right? Unswerving focus on the law. It's like, oh, really? I could have been watching Obama, and I had to come here to hear that in order to be objective. I know that's sort of making it easy for myself to compare to him. But anyway, yeah, I mean, this one sounds really odd, right? Yes, judges should focus on the law. It sounds so simple, but it's actually much easier said than done. And much easier said than supported by people who want a lot of things from the government and who, despite all their lip service to, oh yeah, uphold the law, we want the rule of law, lobby for all sorts of ancillary things that are at odds with that which is legally authorized. An objective court must ruthlessly deflect all extraneous considerations that pollute our discussions of how courts should rule. What do I have in mind? A lot of things. And these I list on the bottom of the front page of your handout. Now, I'll just say a little bit about each of them, and again, we can talk and clarify if you like in the question period. There's a lot more that one could say about all of these, but quickly let me just comment on several of the things that often infiltrate discussions about judicial review. When I say courts have to ruthlessly deflect the extraneous, they must dismiss calls for courts, for instance, to follow the lead of foreign law, which has been increasingly fashionable in the last 10 or 15 years. Because, you know, the French are so much more civilized when it comes to what are they more civilized about besides eating and wine and stuff like that? Capital punishment, or how they treat juveniles, right? Or, oh, the Germans are so good on internet privacy and things like this. Well, now look, obviously, I think pretty obviously, good reasoning, yeah. Where there's good reasoning about law, we need to pay attention to that wherever it comes from around the world. However, foreign law isn't American law. And our courts, right, our justices swear to uphold this law, this Constitution, my handy Constitution, not foreign law. So foreign law per se is completely irrelevant, right? Arguments, fine. Arguments about better ways of understanding our law, if they genuinely are better ways of understanding our law. But per se, foreign law is irrelevant. Similarly, courts must resist calls for deference, which always sounds so, modest and unassuming, and those nice things that you might like in somebody to have dinner with, okay? Deference to the will of the people, deference to the other branches, deference to the experts. Now, this gets a little bit tricky because sometimes something like deference is called for. For instance, there are technicalities in law or in life where a court should know its ignorance And yes, call upon experts in certain technological fields or health fields to get the information that they need. Now, truly, that's not deference, but it's, yeah, I need to inform myself in order to make a good objective decision about the law here. But they should not defer the law, which is what they're supposed to be upholding, right, to, oh, this is what the other branch thinks, or this is what the masses want. Okay, but that's not the question for the courts. The question is, what does the law demand, okay? Now, again, it gets in because, well, deference, that sounds so sort of nice and modest. Beside the point. It's a shirking of their obligation to judge the constitutionality of what's going on of government practices. That's their obligation. Yet another red herring, the claim that the court, well, basically, the red herring is balance, calls for balance. Balance, you check, is your wallet still there as soon as people start talking about balance. Now, again, I don't mean every time anybody ever uses the word it's inappropriate, but I do mean typically you need to slow down and find out exactly what they're advocating. It has this nice aura about it, the word balance, right, of, oh, reasoned moderation. But it is frequently invoked to subvert the primacy of the law. You need to, again, whenever balance is invoked, you need to ask some simple questions. Balance of what? What are the two or more things that we are balancing? For what end are we supposed to balance these things? By what standard are we supposed to balance these things? And what would be balanced by a certain ruling have to do with the actual law? Bottom line. Courts should never balance law with other things that seem desirable but aren't what's legally mandated. To do that is to subordinate the law. A few more entrenched and even more corrosive, or I should say, more entrenched and more corrosive are a few other traps. Precedent, previous courts' rulings. Objective review demands that courts discard mistaken precedents of legal interpretation as if they were the law. They're not. And judges swear to uphold the Constitution, not what previous judges have thought about the Constitution. They might have been right, they might have been wrong, but they're swearing to uphold the Constitution, not the holy God of precedent. A further distraction, the popularity of certain rulings. Well, would this ruling be divisive, right? Or would this ruling enjoy mainstream support? Who cares, right? In fact, social harmony or discord that a ruling on marriage or guns or immigration or abortion or whatever might generate, that's not for the court to worry about. That might be for the cops to worry about. That might be for the politicians running for office to worry about and so on, right? But it has nothing to do with whether or not the law in question is constitutional. That's the court's assignment. Yet another distraction from the law, the size of a ruling, the scope. Well, a lot of jurists ask, shouldn't we tread lightly? Shouldn't we leave a light footprint so that the people get to have the law be whatever it wants? It's the size of a ruling that's important. This is what the minimalists, for instance, argue. And there are minimalists across, by the way, across the political spectrum, left and right. You'll find minimalists from Cass Sunstein to Alito and John Roberts. I mean, they're all over the place. But what these people think is it's the size of a ruling that matters, the narrowness of its reasoning, or a very small impact, or a small divergence from previous rulings. All of these considerations, again, that are so dear to the minimalists are utterly beside the point. Laws have differing scopes. The application of some laws will have significant effects, of other laws much smaller. The impact of an objective ruling will be as large or as little as that law decrees. But to insist on one size fits all, and that size should always be small, modest, that's a distortion of actual law. Finally, our friends who espouse a living constitution and who want to aspire to our system reaching its ideals to the greatest degree possible, it's hard to argue with that, right? I mean, who doesn't like ideals? Who doesn't like justice? I mean, it might depend on the ideal, but that you're talking, right? I mean, there are ideals we could think of that you might not think are so ideal, certain versions of equality and so on. But yeah, should we realize our ideals? Yes. But while a better legal system or government system is always desirable, if there are changes to be made in our system, there are ways and people who should try to make those changes. It's not the role of judicial review, however, to bring us to a more just society or even a more libertarian society, right? Their assignment, again, is to illuminate the law, the existing law. So this is why I say, you know, on the one hand, it seems, well, yeah, focus on the law. Yeah, but then it's amazing how quickly discussions of how courts should do their job get sidetracked by all this other stuff, which might have its place in certain political discussions, but don't have any place in a court that's serious about fulfilling its function to uphold the law and let those who want to change the law change it through the other means. Okay? All right. So finally, let me say a little bit about the third question I said I'd take up. Who should be on the court? What kinds of people would be suitable judges? I just want to say a few things about this, addressing it at two different levels. A few remarks on each. First, in terms of jurisprudential philosophy, or the kind of school of thought that judges should have, here really I basically want to tell you who should not be on the court. Now that could be a long talk in itself. No, but at the risk of alienating some of you, perhaps surprising some of you, originalists should not be on the court. And I raise them because I think they're the ones that it's most natural and tempting for a lot of people who have any interest in objectivism to think are the good guys or the right kinds of judges. So let me just say a few things about originalism here. Originalism is roughly the view that the meaning of law is the meaning that its terms had at the time that it was enacted. Law's meaning is fixed. As Justice Scalia explains it, originalism is the belief that the Constitution should be interpreted to mean exactly what it meant when it was adopted. Okay, close quote. Now this is attractive because originalists oppose certain things that should be opposed, and they seem to stand for objective law. But actually they swing from, what they represent is a swing from opposing subjectivism in certain alternative theories to embracing intrinsicism. The idea that meaning is just given, that it inheres within certain words, and objectivity is a matter of recognizing ready-made truths. Now, I've given several lectures and written several papers that critique this fairly intricately, and I don't want to rehash a lot of that tonight. I do draw on Ayn Rand's theory of the open-endedness of concepts, the objective open-endedness of concepts, to explain the difference between original meaning, as the originalists mean it, and objective meaning. So again, I don't want to go into all of that tonight, but I do want to say a little bit more just to indicate why I think we need to be very suspicious of originalism. One might well think, at this stage, you still might be thinking, now wait a minute, Smith. You say, I've been saying, objectivity requires that courts go by the law. Isn't that what the originalists say? No. When you scratch past the surface, they endorse going by the lawmakers, the authors of law, and that's not the same thing. The objective meaning of a word depends on the nature of the object that the word refers to, not on what a group of people think about the nature of that thing on any given date, 1787 or 1865 or 2016 or whatever it is, right? The latter is a form of primacy of consciousness, of subjectivism. Maybe the authors of the Bill of Rights didn't think that speech could encompass talking on a telephone. A what? A tele-who, right? That doesn't mean it doesn't encompass that. They didn't think that, but they didn't know. Maybe the authors of the 14th Amendment in the 1860s didn't think that equal protection of law entailed that public education shouldn't be segregated by race. But that doesn't mean it doesn't mean that, right? They didn't think, they didn't think that. They didn't realize that. But I hope you see the point, right? What certain people realize at a certain point in time is not the objective meaning of the words they're using, the concepts that they're using, of what the laws actually refer to. Originalism venerates lawmakers, what those guys said, as opposed to what the laws mean. Listen for a minute to Randy Barnett, who is one of the leading lights of originalism, and truly, in many ways, one of the most sophisticated and one of the best of the originalists, and a person from whom I have to say I've learned a great deal in reading his work. But I've also learned, I think, what's wrong with his work and what retains this subjectivism in just about every form of originalism that I've seen. And I put a little of this on the handout, I think. In his long book on this issue, Barnett at one point assures us that originalists don't need to ascertain the content of real rights any more than whether they need to figure out whether some activity truly is commerce. Let's say the Commerce Clause is up in a dispute before the law, as it sometimes is, right? No, Barnett assures us. Courts don't need to figure out the real nature of rights, the real nature of commerce. He says instead, and I give you this quote, instead they can seek either the original intent of the framers or the original meaning of the text. So you want to get that, right? Original meaning, as Barnett conceives it, and the actual reference of words, the actual nature of rights, the actual nature of commerce, those are two different things. So, another example that's come up in a real case, an infamous case in the 1940s, I think it was, is farming for personal consumption, that you're not going to sell or trade, or you're just farming wheat for you and your family to eat. Is that interstate commerce? This was a real case that the court gave a terrible answer to, okay? Is a black a person? Another, it's a question that's come up, is a black a person? Not the issue, according to Barnett. All we need to find out is what some guys thought, right? What did the lawmakers think when they made those laws? That's what's to govern us. So I hope you can see why the point here is, if you seek objective meaning, don't look to the originalists to try to get it. Originalism is a false savior, and it provides no real security to rights or to objective law. Now, the grain of truth that seduces us, I think, is it is illegitimate to interpret laws in a way that changes the subject, that uses language to refer to something utterly different, utterly different in kind from what it was intended to refer to, right? To pretend, for instance, that a law about banks that clearly was intended to refer to banks in the financial institutions sense, as opposed to bodies of land at the coast, something like the Outer Banks of North Carolina. Sure, that kind of bait and switch, that would be illegitimate. But it is legitimate to improve upon the original state of knowledge of a subject. And that's what we do when we understand the First Amendment as now encompassing speaking on a telephone or speaking online or things like that, right? Indeed, it's essential to do that sort of revising and updating according to knowledge if laws are to refer to genuine phenomena, if a law about religion is to refer to religion and not just what was thought about a religion when that law was passed, or what was thought about such and such when that law was passed. Okay? So again, one way of putting this is to say, we must be faithful to the laws, not the lawmakers. originalism's intrinsicism ultimately collapses back into subjectivism, the rule of some guy's beliefs. Getting in bed with originalists in law is akin to getting in bed with the conservatives in politics. I'm sorry, but it is. I want to scare you into thinking about this. If you're, I want to, or maybe entice you to read the book, because there's a long chapter talks in detail about a couple of species of originalism. And the infirmities of originalism, I really think, only fortify their opponents, because once you press at originalism, it's not hard to find problems, and then it makes the alternatives, some really bad alternatives look all the more attractive by default. So you need to know what's wrong with all of the dominant competing theories out there, okay? And again, a couple of my articles that I list there, if you just wanted to zero in on this issue, I could point out which of those do zero in on exactly these issues about the differences with originalism. But let me say just a little bit more about personal characteristics. So again, switching topics a little bit here in terms of who should be on the court. Is there anything I can say about more personal characteristics or their qualities or their skills that would especially suit a person to be, to engage in the right sort of objective reasoning on the court? Here, the only things I talk about in the book are fairly simple but important. I think, two basic things, qualities, are needed in the kind of people who would make ideal justices. Intellectually, the person needs to be a really astute conceptual thinker, skilled at thinking in principle, at distinguishing the essentials from the peripherals on an issue. That is so much at the heart of what judicial reasoning consists of, right? You're continually asking, now is this a case of that? Is this speech? Is this the establishment of religion, right? Is this a search? Is this an infringement? Is this a tax or a penalty? You're constantly classifying. And you're facing arguments that say, the competing sides typically are telling you this should be classified this way. No, this should be classified this way. Well, you need an astute, sophisticated, conceptual thinker who can understand the basic principles guiding the entire legal system and then see through to how it applies in the particular cases. Okay? Morally, you need a person of integrity, specifically in two forms. The person has to have the self-discipline to confine his opinions to his authority, to restrain himself from any temptation to impose his own personal political views, however heartfelt, however sincere, however reflective, however perhaps right and true and valid and justified, right? Still, he's got to restrain himself from imposing those on the law, which is what he swears to uphold. But much less appreciated, and at least equally important, the person has to have integrity in the form of the courage to exercise his duty, his responsibilities, fully. I mean, we often hear that judges shouldn't impose their views. What we don't hear nearly enough is, but they have to have the chutzpah and I don't know, whatever that goddamn stuff they need to do, to say, no, the law says no. Even if the law has to say no, 88 times out of 90 because of the bad laws that the legislatures are passing, right? If the Constitution says no, they have to have the chutzpah to take the political heat that they're going to take by standing up. I mean, as I've put it elsewhere, they need to have the courage of the Constitution's convictions, okay? They need, and our friends at the Institute for Justice talk about judicial engagement, and this is very much, I think, what they're talking about. Judges have to have the conviction and the heart to fulfill their responsibility to the law and not just defer or, oh, well, we don't want to make waves. No, when you're swearing to uphold the Constitution, that means you have to make whatever waves vis-a-vis the bad laws that others are feeding you accordingly. All right, just a few thoughts then to wrap all this up. Getting back to objectivity. Objectivity isn't rocket science, but it isn't common sense either. And particularly when the subject matter that you're trying to be objective about is complex, as it is in higher reaches of abstraction. In other words, if the subject matter itself is rocket science physics, Or the legal concepts, such as rights or justice or equality, and how those apply in particular cases. Yeah, objectivity there is demanding work. It's doable, but it's a definite discipline. And we mustn't pretend it's easier than it is, because I think if we peddle a false model of objectivity, we're not going to get objective law. And it does no good to spout a model that can't be practiced, that isn't faithful to the actual meaning of law. Now, my analysis doesn't give us a nifty formula. I cannot tell you how disappointed I remain to this day that I can't give you something as simple and bumper sticker ready as go by the text or go by the public understanding. You know, the originalists, they've got it all over me in terms of short, nifty labels. And I really wish I could come up with something better. But legal interpretation is sophisticated conceptual work, and it can't be dumbed down to the level of mechanical instruction. My account simply says to judges, be objective. Appreciate the rigor of that. Go by the law, only the law, logically, as the full context shows its meaning and its proper application to be, based on an understanding of the legal system's purpose and, crucially, of its authority. Resist all those peripheral considerations that vie for supremacy over the law of the land. Now, earlier, toward the beginning of the talk, I asked whether courts can be objective, noting that many people assume they aren't. But emphatically, I think, they can be. That doesn't mean they can be infallible. That doesn't mean an objective court will never make a mistake. They will. We can't devise a method for turning us into some sort of foolproof beings or getting foolproof decisions. But to say that they can be objective means they can be honest. They can be logical in the full context of legal power, and thereby they can get the law right. And it's always useful to remind ourselves of the stakes. Laws use force to protect our freedom. When laws are well designed and well exercised, they do that, and that's a tremendous value for all of us. But when good laws are misunderstood or misapplied, their protection is lost. So it behooves us to sharpen our understanding of what judicial review, what objective judicial review does demand, so that we can demand that of the people who place people on the courts. And again, as some of you might have heard me say in some other talks, when we take liberties with the law, again, whether we do that deliberately and brazenly or inadvertently, either way, when the courts take liberties with the law, we are taking liberties. Okay, I'll leave it at that. That was a little longer than I intended, but we definitely have time for questions.
I'm wondering if there's a difference in objectivity of applying the law between lower courts and higher courts on appeal. And I'm thinking particularly if a court is hearing, let's say, antitrust case. How do you go by the law, as you're describing, versus not imposing your own, let's say in this case, right beliefs? What I'm trying to get at is what exactly is the law that you're applying versus trying to do something else?
Well, okay. I mean, insofar, if you're a justice on a court, you swear to uphold the law as it exists, right? Knowing that you might not personally agree with all of the laws that we have, right? But if you shouldn't sign on to be a judge if you have such deep objections to certain of the laws that you felt like you just couldn't in good conscience do this, right? But if you're swearing to uphold the law, then you should uphold the law insofar as you think this is the valid, duly enacted law of the land. What gets exactly tricky, and again, I talk about this a little bit in the last chapter, which is where I talk about But it's one thing to talk about judicial review in an objective legal system where everything else is working basically as it should be. That's not the system we have today. And one of the problems is that as soon as you inject into a legal system any inconsistent elements, it creates tensions which cannot be resolved in a fully objective manner. And I think in a way that's part of what your question is getting, right? I mean, once you have laws that are inconsistent with the basic authority of the legal system, now there's no good way, truly, to settle them, because you're going to have to sacrifice, well, you're going to have to sacrifice one or the other. Either the propriety of a legal system overall or living by what you have made according to the lawful means. So, okay. This really points to the importance of the authority of law, which again, I get into in a couple of chapters, and the importance of integrity of law, which is one of the lessons I learned really from writing the book, how vital the integrity is. And for that, what a responsibility lawmaking is. Even while my talk tonight is focused on the courts, and the courts are easy to criticize in a certain way because they're relatively small in number, and especially in the highest courts, they have these lifetime appointments and so on, and big ramifications. But one of the things from, again, studying the courts that I came to appreciate was how crucial lawmaking is, both in terms of the very concept, what ideas they're putting into these laws, let alone then the actual articulation of them. And so much goes wrong there that creates pressures on courts that are in some ways irresolvable, but still have to be resolved, and I think have to be resolved according to what the law is, not on this I'll be very clear, not according to what Ayn Rand's on the court, and suppose you think Ayn Rand's right about everything. That doesn't mean as a justice she would be entitled to enforce, but I know better, kids. So no, as a judge, you're enforcing the law, not giving us the benefit of your knowledge about what the law should be. So in that sense, even the judge who's correct about what's wrong with certain of the laws has to abide by the law. Maybe I just should have said that in the first place. Anyway, sorry. But I mean, an interesting and good question. It's like, yeah. It's
your comment about foreign law brought to my mind, I happen to teach information systems. I've been an expert witness. And the technology is global. The law governing it is theoretically global. We have an international patent treaty that covers the world, but the same law is being interpreted differently in different countries. And in particular, American judges are extremely pragmatist, and they say that you cannot patent an abstract idea. Whereas the technology in my field, which is software, is all abstract ideas. We don't invent anything else. Mm-hmm. And so the law, as interpreted in the United States, is delusional. It says that you cannot patent the only things that people in my field can invent. Mm-hmm. What can we do about this?
Well, that by itself, doesn't show that it's delusional, right? It shows that there's a difference of opinion about what's patentable. But I mean, really what's part of what I find interesting about what you're bringing up is just international law is a joke. Because as a concept, because who's sovereign to decide it, right? In the United States, when courts differ, it goes to a higher court. And we have a final end of the day resolver, right? Like their decisions or not, the Supreme, when the circuits are split, usually then the Supreme Court will take a case to resolve it once and for all, right? And that's what's missing in international law. Now, it's a separate question about the merits, the substance of their views on patents and, whether abstract ideas are patentable. That gets more to the content of the law, which is an interesting question, but separate from the judicial responsibility. But again, when you start talking about, when we all start talking about international law, we're talking about independent regimes, which yes, sometimes they will, join international treaties or make what they call international law, but without a clear enforcer or even ultimate resolver of such differences about what even is patentable. I mean, it just shows the ridiculousness of trying to have a system without a final say on what is the law and what will be enforced.
So would you be in favor, for example, of a global patent court that would be the final venue for appeal of patent cases?
I'm not sure. I'm really not sure. I could see reasons why, in today's world, there could be great benefits to a lot of international agreements about how certain things will be done, what the protocols will be, what the conventions will be in terms of what we recognize and so on. I could see lots of benefits to doing that. At the same time, insofar as I'm not clear about how this would be enforced, I'd really need to think a lot more. I'd need to think that through on both ends to figure it out.
Thank you.
Sure.
So, given that the Supreme Court must rule according to the law, in their deliberations they may often discover that the law itself is bad. To what extent do you believe they should be proactive in telling the world about how the law should be written?
Oh. I don't think they should be very proactive about that at all. Now, the quick qualification is, if they're finding bad law, it depends on what it is that they think makes that law bad. If what makes a given law bad is it's unconstitutional, yes, they should shout to us about that from the high heavens, right? Because their job is to police the law, in effect, by the Constitution. So when they're finding what's defective about some law is, this ain't compatible with the Constitution, they need to say that loud and clear and strike down that law and make clear that they will strike down any laws that are defective on those grounds. But if it's some other grounds for their thinking, and again, they might even be right about this, but if it's some other grounds for their thinking that the law is bad, that's not their business, right? Run for office if they want to tell us what better laws we should have or something, if it's not on constitutional grounds.
So they shouldn't give us the benefit of their wisdom and deliberations?
No, I really don't think so. I don't think that's their job, right? I mean, they're there as the law keepers. They're not there as the philosophers of law. I mean, they can retire and go do that, but they're there to police the law. And there are others who are supposed to be talking about and thinking about what should be our laws. Yeah.
Thank you. You make a point of singling out originalists, and I understand that in terms of constitutional theories of people who actually care about the Constitution is probably the greatest competition. But if those are the ones you singled out, and my question is, I guess, we would all love to have a court of 9 objectivists. That's not likely to happen today, tomorrow, over the next 30 years. So, I mean, are you suggesting that you'd rather have a court of 9 living constitutionalists, 9 Sotomayors, or even 9 Kennedys or Stevenses, rather than 9 Scalias?
No, that's a good it's a good question. And I singled the originalists out for this audience again because I think the originalists they're so close but so far, and they're the nearest ones, and they're the ones that it's easy for us to, I think, mistake as they're the right guys. And I love what they're against. Right? And you cheer them on when they're ridiculing what's wrong with the popular constitutionalist or the aspirational living constitutionalist or the minimalists. But truly, I think they're no better in the end. So it's not that I want 9 living, but I really think it's 6 of one, half dozen of the other. I mean, you'll get from all of these justices of the different stripes, living constitutionalists, different versions of originalism, you'll get some good decision, some good reasoning on some cases, and some bad. And sometimes in the very same opinions, you'll get some good and some bad. So so on the one hand, no, I'm not saying I think we'd do better with 9 living constitutionalists, but that's not to say I think we'd do better with 9 originalists. No, I don't. I mean, let's talk about Scalia for a minute. Scalia is atrocious on rights. He has said many times, you want rights? Don't come to the Supreme Court. Put it before a legislature. Rights are a matter of popular vote. That is a very standard originalist position. What refuge did he take? Now, but again, you can find similar thing or scary in comparable ways from every which one on the court, be it Kennedy or the moderates or Sotomayor or Kagan or you name it. Yeah. So I'm sorry, it's bleak, but it's bleak.
I just have to ask one other follow-up, which is, can you name, you said you'll find well-reasoned decisions and poorly reasoned decisions.
Oh, yeah.
Can you name a well-reasoned decision by the U.S. Supreme Court? One you actually thought not only they reached the right decision, but they got there the right way.
By the right way? Wow. No, but I should say, no, but that's my own ignorance. No, but I want to say, that's because, in all honesty, I don't read a lot of them through. I'll read parts, and I'll see, now that's really good reasoning there. And again, part of this is just my own interest or lack of interest, but part of it is I see such inconsistency that it demotivates me to stay with any one of them or really follow closely. But there might be lawyers here who could answer that question better. I wouldn't be surprised.
I saw a good one in 1936.
Sometimes.
Hi, Tara. You brought up in the beginning of your speech how there exists a non-arbitrary distinction between the spirit of the law and the letter of the law, and sort of how context is meaningful. Is there some sort of thought process or some sort of way that one can check his premises and know that he's applying the sort of spirit law in the right context? And I ask this because I know you concluded your speech with the fact that to this day there's no real formula that you have to sort of finding an objective law and those sorts of things. But just in applying it contextually, is there some sort of way that one can just make sure he's going along the right decision or a right path of reasoning?
No, interesting question. Again, good question. A couple of things. Well, so first I just want to clarify. Right, well, I don't think there's a nifty little formula. Okay, it's not paint by number. But, if we want objective judicial review, we need to have a good working understanding of what is it to be objective. What's the guts of being objective in any context, right? Anybody judging anything, making any decision, trying to reach any conclusion. And then, how does that apply in the law? And it does apply in large part in this contextual way. And the main, I think, help, and I referred to this, I didn't put it in exactly this way, but a real help in understanding the spirit of the law in a proper way is thinking about the function of the law, the legal system, the law broadly, right, of the legal system, and the authority of it. Government law has this incredible power that we don't give anything else, right? They have the power to force you to do things you don't want to do. He can't do that to you. He can't do that to you, but the government can. And that's okay. That's legitimate for the government to do that for certain reasons, right? So they've got a monopoly on this use of coercion. Why do they have that? To do one thing, to protect our rights. If you keep that in mind, that's their reason for being, right? That is their reason for being. That is their function. Everything they do should be geared to advance that function and in no way undercut it, right? So that's the context. That's the principle that animates our system, that gives it the authority that it has to boss you around and say, no, if you don't do that, we're putting you in jail and we're going to be justified in doing that, right? So you've got, I think, coming back to the function and the authority is very helpful often. It won't answer all questions, but it's very helpful in gearing you to the kinds of considerations that should be relevant and irrelevant then in getting, so what does this specific law mean? So function and authority you want to keep coming back to. They can be helpful.
That really sort of helps connect like the purpose of the beginning when we talked about function.
Oh, I hope
That
so.
makes a lot of sense now.
Good, I hope so. Good.
Hi, Tara. First, a quick comment. The book is terrific.
Thank
And I think you're selling yourself short when you say that unswerving focus on the law is obvious.
Oh.
I don't think anybody really gets that. But that's not the question. So what do you do, or what do courts do about parts of the Constitution that we might refer to as terms of art, right, that are kind of rooted in their time? The Privileges and Immunities Clause comes to mind. You interpret that according to the objective meaning of those two terms, and you don't get to, I don't think you get to rights, which is what the term actually means. It means to protect substantive rights, but it's written in a way that if you think about the meaning of privileges and immunities, I don't think you get to rights, although, I mean, that's debatable. I might be wrong about that.
Yeah.
Another quick example would be well-regulated militia. There's not really a current, you look up in the dictionary, you're not going to really get what the founders meant by that. So if you look at least, those two provisions, and you could even broaden the question to vague, difficult to interpret parts of the Constitution, I at least can see an argument from an originalist standpoint. Look, there's no current analog to these terms. They're rooted in their history.
Yeah.
If we don't look at their history and understand what the drafters say of the 14th Amendment meant, we're left with a blank, an ink blot, as Judge Bork said.
I'm not sure. I'm really not sure here. But I think I think one kind of case you raise is interesting. If there are truly some terms that we don't use those terms anymore. I mean, they're obsolete. Let's say they're really obsolete for us, but we understand that they meant something very definite in their time. Then I would think you'd have to go by if it's not that we've learned more about the nature of the phenomena, but rather we no longer even refer to those phenomena or something. If it truly was a term of art in that sense and it had a clear, understood meaning that has, and it's not that there's been any subsequent development in our knowledge or understanding of what they were talking about, then I think it would be legitimate.
Yeah, so the objective meaning is the historical meaning, or is the original?
Well, that's the only, again, if it's not the case that we now know better about what they were referring to, it's like, no, we're not even interested in that anymore.
Yep.
But it did have a role, and it played a role, and there's nothing in what we have learned about anything else that would supplant that or show that that was illegitimate to have given the specific meaning that they gave to it. But I would want to think a little bit more about that and come up with more concretes to make this more intelligible to everybody. Yeah.
Thanks.
And that's something we can talk about some more too. So, yeah, thanks.
So on this handout, you listed several common lures away from the focus on the law.
Yeah.
And you mentioned deference, right?
Yeah.
And so when you talked about that, it reminded me of something that I've been following in the news about the Patriot Act being reviewed and being considered illegal or declared illegal by one judge. I forget his name, Leon or something like that. And specifically, I think it was like Section 702. And so I believe the gist of it is that he said, okay, yes, it's illegal, okay, but I'm going to issue some sort of a stay of, action on it because I want Congress to, have a chance to deal with the fact that it was extended for another 6 months, right? So rather than stop that, the collection of data under the law that he considered to be illegal, he's like, okay, well, let's just let Congress kind of deal with it. And then we got the I think it was the USA Freedom Act out of it. And now, as I learn more about it, we're yes, they have to get a warrant, but now they have more types of data that they can collect. It's even more broad about what they can collect. So is that an issue of improper, I guess,
Well, it
deference?
sounds like it, that is. I mean, if a judge or a whole court, right, if they come to the conclusion, this is not legally kosher, that should be pretty much the end of it, I think, right? And right, that sort of, oh, but let them do it. Because also, if you think about the design of the separation of powers, it's, and checks and balances, that's premised on each of the branches fulfilling its responsibility, not each of them passing the buck, as it were, or shirking to the next. No, it's like you've got to do what you see as Constitution. You've got to do your role in making the laws in conformity with the Constitution, and you as executive should only sign what's constitutional, and you as the courts should only enforce what you and strike down what you think isn't. Not, oh, but what do they think? They've had their chance. I mean, each has to fulfill its independently. That's the way the checks will actually work, which is why I think the deference thing is often misused. But it's like, no, and that's why I say they have to have the courage to step up and do their thing, not just to refrain from imposing. Yeah, but you need to fulfill your part. Otherwise, the checks and balances, the separation of powers won't work in the way it was designed to, and that's what we have. Everybody just defers to the other, and then you get, but what they're deferring it on is the Constitution ultimately. Yeah.
Yeah, I wanted additional clarification about the very first question. In terms of, obviously the Supreme Court justices, their job is interpreting the Constitution and enforcing the Constitution. But most judges, of course, are not at that level. And a lot of our laws, I think you could objectively say, are not constitutional by certain standards. So if you're a judge and, you're faced with this, do you go all the way back and uphold the Constitution? Or, for example, with the very non-objective antitrust laws, do you try to uphold a law that is inherently non-objective and probably unconstitutional?
Yeah. I'm kind of not sure what to say there, because there are things to be said on both sides. But it's not for, and now here, I think, I'm pretty sure it's understood that different levels of courts, different tiers of courts, are known to have certain limits to there are limits to what's legitimate, I think, for them to engage in. Now, and here I should say, I'm not a lawyer and I'm not absolutely positive about this, but I'm pretty sure that they are at different tiers seen as limited in terms of the scope of what they are supposed to be bringing in to the given kinds of case that they're hearing. So it's not that we want all justices to always going to the broadest or the highest powers. I'm pretty sure that at the very lowest levels of the courts, they're just supposed to be sort of more locally focused on the nearer to the case laws.
Oh, yeah,
right?
Yeah, I'm sure you're right about that, but do you
Right.
think that is as it should be?
I'm not sure. Because I'd want to think more about I think it depends on two things. If the more bad laws you have, the more you kind of want to shake up the laws and say we all should be paying more attention to constitutionality, because by not doing that, we've now got so many bad laws that are at odds with the Constitution, right? At the same time, I can see reason, at least in a more basically healthy system, where the great preponderance of your laws really were the kinds of laws they should be. There might be reasons for thinking that there's no need, there's rarely going to be need or benefit from, in effect, local low-level courts having to invoke the broader issues. I'm not putting this well. The worse your legal system, the more you're going to want
People with integrity who actually say...
Right, who actually are asking the broader questions, right? The healthier your system, the less there's going to be a need for that. And there may actually be some benefits in not going to the highest issues too readily.
Right, in a traffic court.
And because, right, and just because, yeah. And I mean, there often are cases, right? They're not the interesting ones. I mean, they might be on Judge Judy. I don't know. They're on TV. But I mean, but there are lots of cases that are settleable, in a fairly straightforward and cut and dried ways, and it might have to do with technicalities or just, again, the nature of certain straightforward laws. But it's when you get to the higher abstractions that reasonable differences arise such that you think, well, there's something to what that side is saying about was this a search, and there's something to what that side is saying, and it's kind of hard. Now, when I say reasonable differences, that doesn't mean the two sides are ultimately equally rational, but it means, yeah, this is not easily resolved. It takes some real argument and thinking, and so those are the ones that are going to get to the higher levels.
Thank you.
Sure.
I sincerely want this to not be a redundant or stupid question, because I believe in both. Is a law valid if it's wrong?
That's a very good question. And in one very important sense, no. But it's not that easy, right? I say in one very important sense, no, right? I mean, really, at the heart of all objective law is that law exists because and what validates it as objective law is the fact that it is helping to serve the function, the purpose of the legal system, protecting our rights, right? And when Ayn Rand talks about this, and again, she doesn't talk a lot about law, but when she does talk about law, I mean, she makes clear that at the heart of what an objective legal system is the laws are doing what they should be doing. So if a law is wrong or bad or invalid in that sense, that's not a good law. But at the same time, so once you have a legal system, now you've got, you're saying in effect, we can't just be governed by philosophy, by even correct political philosophy. We need something between the correct answers to political philosophy and getting the guns out on this guy, right? We need a legal system. We need a system of rules where everybody can know the rules, right? And know, okay, these are the rules I've got to abide by, or else I'm going to be punished. I'm going to be subject to this coercion, right? But in fact, in reality, right, okay, it's going to be human beings making those rules. We might make some mistakes at points, but if the system is basically a right-minded system, a right-intentioned system that is basically functioning in a way to fulfill those right intentions, right? Then I think it would be a mistake to say, oh, you made a bad mistake there, so that one's not valid, or I don't have to obey that one. Like, I don't think it makes sense to think we can have a proper legal system where we're in effect opting out on a piecemeal or case-by-case basis because, for instance, we think that was a bad law, so that one's not valid, so that doesn't have to be enforced. In a way, that would be comparable to the guy on the jury who says, this is bad, I don't like this, so I'm not going to enforce this. No, part of living in a legal system is you live by the system even when it errs, right? Now again, that's if the system itself is fundamentally a good system, a right-minded system, an objective, proper system that might be fallible and make some mistakes, but is basically trying to do the right thing, protect our rights. Was there a follow? I thought you had a, oh, okay.
I just had a quick question, and maybe I'm biased because I'm an intellectual property attorney, but most of what you were talking about was con law issues, constitutional law issues. But do you think that certain courts do a better job of this sort of holding context than others? So, for example, I would say the Federal Circuit, as they're judging copyright and patent cases, that, when the founders were creating things, the Article III courts, they weren't necessarily, envisioning the internet,
right,
the computer,
right,
computers, and being able to, to sort of manipulate and copy things like we can now. That when we come to a social media law, right, publicity, all these sort of newer things, that they're like holding context and sort of going with what the law is versus what it was back then.
So,
you know what I mean?
well, that may well be. I want to make sure I know what you mean, but it may well be that there are some courts that tend to be much better than others, and you're suggesting that the courts that deal with IP do tend to be better.
Because they have to.
That,
because
right.
It's constantly changing
Yeah,
versus real
and that may
property.
well be. I just don't know enough to know, but I could see that being the case. And in some ways, it would make sense that it would be the case in that kind of area where there was less previous law that clearly governed at least certain of the more technical aspects of this, such that they'd have to be
Like real
going by
property,
the
we
current
always had dirt
realities.
and people fighting over it.
Yeah.
Or whatever, but whereas technology is changing, you have to keep evolving and
Right,
interpreting the
and
law
paying
as to
attention, yeah.
what it is. what
No,
the
I mean, as
intention
long
is.
as they're going by the right, you still want it to be governed by the right principles of property and thinking about property in the right ways, but if they're basically doing that, yeah, it could be. Any other questions?
I can ask one more follow-up.
Okay, sure.
You talked about precedent, and a couple people alluded to this earlier, and you were talking about the proper roles of different judges. And of course, there are proper roles, and one of them is the Supreme Court is at the head of the U.S., of all the federal courts, and the California Supreme Court is ahead of all the lower state judges, the Court of Appeals, and the Superior Court judges. And so when you talk about precedent, I think there's an important distinction to be made between being a Supreme Court justice and being a U.S. District Court judge. If the U.S. Supreme Court has said antitrust law, the Sherman Act is constitutional, as a district court judge, you really don't have the option of saying this law is unconstitutional.
Right.
You can write whatever you want in your opinion, but you cannot, contradict.
No, I think, yes, you're right. And I meant precedent just in the sort of Supreme Court going by previous historical precedents of other Supreme Court cases, but you're quite right that there are these sorts of tiered distinctions that make a difference to what it's legitimate. Yeah, they can.
That makes more sense. The Friedrichs case yesterday was very interesting. I don't know.
Yeah, this is the Union case?
This is the Union case coming out of California.
Yeah.
And liberals, in order to get the fifth vote, were strenuously trying to argue precedent to try to get Justice Scalia to vote with the 1977 precedent.
Yeah.
I think and I hope they failed, but it'd be interesting.
And one of the interesting things about precedent is, you'll often hear it invoked when people object to a ruling as this is at odds with so many decades of precedent. This was one of the big complaints we heard about Citizens United, right? A lot of people saying, oh my God, we've had campaign finance regulation for 70 years, as if that's the most important thing, right? What have we been doing for a while? Yeah, but if we've been getting it wrong for 70 years. No, but also the thing about precedent is the complexion changes a lot depending on what the age-old practice was that needed to be upturned, right? Think about different race issues. Depending on the issue, you can make upholding precedent or overturning precedent look much more attractive. Okay. All right, last question.
Could you talk a little bit about what you think we can do to get from where we are to where we want to be?
I'll restrict it just to this issue of sort of law and courts. I do think we should pay attention, for instance, we're in political campaign season, right? And this season, some of the candidates have been making proposals about Supreme Court justices and the kinds of persons that should be on them and constitutional conventions and things like that. Cruz has made some remarks about this and so on. So I think we need to take often people do, if they think there are likely to be vacancies on the high courts, right, in the next presidential tenure or something, they'll often pay attention. But I think we really do need to pay serious attention to the kind of people that are being appointed to the courts. We need to pay attention now as well as when we have the next round of appointments and debates about the different candidates and so on. That's something else that we should be voicing our opinions on and not falling into the false dichotomies of the originalists versus the living constitutionalists. Pointing out what's wrong with the knee-jerk charges of activism and the need for active courts who will actively be active in the sense that they'll actively police, the goddamn Constitution, right? Which is what everybody likes in theory, but then they also like balance and precedent, and they don't like social divisiveness and all this other junk, which isn't the law. I mean, and part of the ongoing way of talking about this is by talking about the rule of law. And what that means, and it's always so helpful to identify the foils, what it does not mean and what it excludes. So when we've seen all this abuse of executive privilege in recent years, and we saw a lot of it under Bush as well, you have to, I mean, God knows you saw a lot of it under Bush as well. But when we've seen that sort of ignoring of the law, when we see the Congress so often enact laws that they know are kind of vague and woolly, but we don't want to take the heat by sorting it out and saying something more decisive ourselves. We'll let the courts sort it out. I mean, all that kicking it to the other branches, all of that is abject dereliction of duty to the thing that they swear to uphold. So that's the kind of thing which on an ongoing basis, calling people's attention to the rule of law. Do we mean it or not? Do we mean it or not? No, you don't have unilateral suspensions of Obamacare, right? So I think attending to the rule of law, and it has gotten more attention. In the last year or two, it has gotten more editorial attention, but that's something I think we can have a steady drumbeat on, as well as the importance of upholding the Constitution and getting the right kind of persons on the court. There was an interesting article I'll just mention, and it was just a magazine article, so it wasn't a big, long, heavy read. But back this summer, and it was, I have to say, this very same Randy Barnett, who I do think is a subjectivist at heart, but he was co-author of a pretty decent piece on the next time there's a Supreme Court nomination, what are the kinds of questions we should ask? And he made some very good suggestions in there. He and Josh Blackman were the other. And you can look it up online. I think it was in the Weekly Standard. But it was good about asking, would you upturn precedent? Because they'll always say, well, don't ask me about specific cases. I can't tell you about an abortion case or a gun rights case. Okay, but tell me about your view of certain clauses of the Constitution. Tell me about, well, do you believe in ever overturning a precedent? And if so, why? And that sort of thing. So that was a more thoughtful approach to what should go on than you typically see from left and right alike, left and right politically and legally. So, all right. Okay, okay, one last question. Last one.
Okay, I remember some years back, you gave a lecture on pragmatism and why you cannot get good law from bad epistemology.
Oh.
And that at least was the way I understood your lecture on pragmatism. And I don't know, but somehow I hear less of that now. I haven't heard one word criticizing pragmatism today, and I haven't read your book through, so I don't know whether you criticize pragmatism in there.
I don't know if I use the word pragmatism, but I'm no less against pragmatism. And notice, in that list of all this other garbage that I say is extraneous, 90% of that represents pragmatism, okay? So without using the word, oh no, we need to balance, oh no, we need to defer, and all that other garbage. What do you think that is, except, oh, come on, let's be realistic, let's get along, let's be practical. So, oh no, the opposition to pragmatism, I assure you, has in no way, and in some sense, well, yeah. So, we'll leave it at that. All right, thank you.